Boy, we've got a good one today. Buckle up, boys and girls. Um, we're going to be talking about the largest insurance company now in Florida being busted for the way they're handling and manipulating mold claims. That's right. So they're manipulating the law. They're changing the wording in their policy as they go along, even though it's not written in their policy. This is what insurance companies do. This is why I start preaching to everybody who watches my videos. Why would you go into a claim trying to handle it yourself? Whether it's you have a roof claim from a storm, if you have a hurricane claim, if you have a water damage claim, if you have a pipe break, anything, fire claim. Why are you trying to deal with the insurance company? This is what they do. You're going to see it. This is a dandy. We got a good one. Buckle up. Okay, so here we have citizens adjusters intentionally misinterpreting the law. Now, the question is this a direction from management? Because what they're doing, as we will review, they're changing the policy on the fly. Don't worry about this 10 square feet right now, but remember it. I'm going to show you something. But there's nothing in the policy about it. See, if Citizens, who's the insurance company doing this, if they were a private insurance company, this would be a huge class action lawsuit probably. And the insurance company probably wouldn't get in any trouble. So there's that. So here's what we have to review. So they denied this lady's claim who called me, okay, for this reason. They're saying we did not observe evidence of more than 10 square feet of visible mold growth during our inspection, and your documentation did not provide evidence of more than 10 square feet of visible mold growth necessary for remediation as per Florida statute. Okay? Therefore, tear out of the lower walls is not warranted. This is going to get good. Okay? So remember all this. Let's review it again. We did not observe evidence of more than 10 square feet of visible mold growth during our inspection. Wonder how they measured it. And your documentation did not provide evidence of more than 10 square feet of visible mold growth. And they said, per the Florida statute. So Florida statute supposedly says this. We're going to take a look. Does it say it? Let's find out. So let's take a look at Citizens policy. Citizens, this is the HO3 policy, which is your standard homeowners. And this was updated in February of 2022. Okay, so let's look at the mold. Let's look for 10 square feet. See if it's in their policy, right? Because obviously, if they're not going to cover 10 square feet, it should be in the policy. So let's look. Okay, let's just start here. We'll carry on the second part of this page up here. And the next slide. So, you guys see anything about 10 square feet here? No? Here? No? Okay. Okay, next page. This is the top page of the previous one right here. Say anything about 10 square feet, the cost to tear out and replace any part of the building or other covered as needed to gain access to the fungi. Doesn't say anything if it's only over 10 square feet. Okay, the cost of testing. Okay, nothing. Don't see 10 square feet anywhere. Yet they're saying that's the Florida statute. But again, it's not in their policy. So they're changing the language of their policy with regards to mold, changing the language on the fly. I mean, basically, it's like the Constitution, and then everybody wants to interpret it, but it's interpreted one way, the way it's written, but they want to be flexible. No, it says this, guns and freedom of speech, yada, yada, yada. This can't be interpreted multiple ways. The language is there. So here's the Florida Standards of Practice Mold-Related Services Assessors and Remediator Report. Okay. And what it talks about here is the purpose of a mold assessment, determine the source's location, goes through all this stuff. Most importantly, it's on the next page. So this is the part on this page that is really the popcorn for this document, containment. So it talks about that it must be specified in a mold remediation protocol when the mold contamination affects a total surface area of 10 contiguous square feet or more for the project. Containment is not required if only persons who are licensed or registered under this chapter occupy the building in which remediation takes place at any time during the project unless cross-contamination is concerned. Okay? So, all this is saying, containment is one of these. If you ever had mold remediation done, containment is where they put this plastic, almost like E.T. from the movie, where they put plastic throughout the house so people can walk and had the contamination suits. You square off an area, you put the antimicrobial spray, and you put in some other chemicals to kill all the mold and so on and so forth, and then you can remove that quote-unquote containment, that plastic area. All right. So all this is saying is, if it's more than 10 square feet, if it's less, you don't have to put in the containment. That's all it's saying. It doesn't say it's not covered or any particular way. But wait, like a TV commercial. But wait, there's more. Don't forget, when you get a chance, give me a thumbs up, like this video, and also subscribe to the channel. It'd be a big help. Thank you. So let's take a look at the Florida Health, what they talk about with regards to mold and moisture. So here's what they talk about. Who should do the cleanup? Well, they say depends on the size of the mold problem. If the moldy area is less than 10 square feet, in most cases, you can handle the job yourself. What are those most cases? Obviously, if your health is perfectly fine, you're not affected by mold, okay. If you have respiratory issues, if you're elderly, it could be some issues. If there's been a lot of water damage and or mold growth, covers more than 10 square feet, then obviously consult the US EPA guidelines, right? And they're going to talk about doing hiring a contractor to do cleanup, so on and so forth. So this is just basically saying, if there's more than 10 square feet, get somebody to do it. And even if it's less than 10 square feet, if you have issues medically or could be sensitive to mold, don't do it. Doesn't say anything about the insurance company not paying for it, right? Okay, here's something else. We're going to talk about and review Florida's mold-related standards of practice. Okay, so here they talk about the levels. Okay, level 1 refers to a mold problem less than 10 square feet. They have levels 1, 2, or 3, with 1 being the less severe. Problem less than 10 square feet is level 1. Level 2 is between 10 and 100 square feet of mold, and level 3 is more than 100 square feet of mold. All right, remediation methods. So it depends on the type of mold as well as its severity. So the type, severity. Okay. Studying Florida laws tells you how to handle each problem, whether to use a wet vac, air vacuum, detergent, mold removal, cleanup, go hand in hand, so on and so forth. So that's another state agency who gives us some direction. Again, doesn't talk about anything about whether the insurance company should cover it or not, or pay for it. So now we're going to look at the Florida statute. Now we're going to review the law. So the Florida law defines a mold assessment. It means a process performed by a mold assessor that includes a physical sampling, detailed evaluation of data. Okay. So basically, origin, identity, location, extent of amplification of mold growth of greater than 10 square feet. Mold remediation. They're defining it. Means removal, cleaning, sanitizing, demolition, or other treatment, including preventive activities or mold matter of greater than 10 square feet. Okay? This just means they are defining mold remediation as cleaning, sanitizing, demolition, or other treatment if it's greater than 10 square feet. So what should it be called if it's under 10 square feet? I don't know. Yes, the argument from a legal perspective would probably be mold cleanup, right? However they want to call it. But again, when we refer back to the policy, it doesn't say anything about square feet. This doesn't even say, the law doesn't say that the insurance company will not have to cover anything under square feet. It's right here. It doesn't say anything. All they're doing is defining, saying that, okay, the remediation means more than 10 square feet. Are we cutting hairs? No, we're really not cutting hairs here because it's not in the citizen's policy. And the law doesn't say that the insurance companies can deny it or not pay for it if it's under square feet. All they're saying, and they're just defining it, is mold remediation above 10 square feet. You can call it whatever the heck you want to call it under 10 square feet. Mold cleanup, mold sanitation, mold removal, mold demolition, mold wipe down. I don't know what you want to call it, but it's still supposed to be covered by the insurance company. But they're saying, no, the law says, you saw the letter I showed you on Citizens, review back to it if you have to. They're saying, no, the Florida statute said if it's over 10 square, if it's not over 10 square feet, we don't have to pay. This doesn't say anything about that. They're just defining it. It's unbelievable. Unbelievable. So here's the thing about Citizens, though. They can get away with doing it because the state insurance company, smaller claim, it's going to be hard to find an attorney to go after Citizens for that low amount. So again, another insurance company, this time a state-run insurance company, trying to screw people. Thank you for watching this video. Again, my name is Mike Keeler. I'm a licensed public adjuster here in Florida. If you have questions, need help with the claim, this is how you can get in touch with me, by my cell phone, email, and through my website. Thank you again for watching.